that and shift our focus to more breaking news that we're tracking. In fact, we are picking up that there is hearing underway in the top court on petitions against abrogation of Article 370. The top court orally observed today that they will only examine violation of constitution and not reassess basis government decision. The Supreme Court also added that they are not examining any aspect of national interest. To tell us more on that, let me go across to my colleague Harish joining me on the broadcast. Harish, good afternoon. Clear directives and points being made by the top court. If you could help us understand a significant statement also saying that the reassessment is not based on the government decision, and added that they're not examining any aspect of national interest.
The Supreme Court Constitution Bench led by Chief Justice of India Chandrachud is at present hearing a batch of 23 petitions which have challenged the abrogation of Article 370. Senior Advocate Dushyant Dave urged the court to look into the decision making and also look into all the files pertaining to the decision making, and also decide whether it was in the national interest for the abrogation of Article 370. But Chief Justice of India making it very clear through oral observations that it will not it will not reassess the basis on which the decision was taken, the abrogation of Article 370, and it will also not look into whether it was a national interest or not national interest, and will only examine whether this decision, the constitutionality of the decision, which means whether the decision to abrogate Article 370 was in violation of the Constitution, and will not go into the wisdom of the decision makers. So very, very significant statement coming in from the Chief Justice D.Y. Chandrachud. In fact, let me remind the viewers that these are mere oral observations during the hearing. Dushyant Dave also argued that the decision to abrogate Article 370 was illegal, arbitrary and unconstitutional, and the article was abrogated after amendment of Article 367 and 368, and he argued that it could have been done only by the Parliament, and it could have not been struck down through an executive action like the decision taken by the President. And he also argued that before such a decision was taken, the concurrence of the State Assembly was required, because this was a decision which made sweeping changes into the geography and history of the entire Jammu Kashmir. And also, it was wrong to equate governor with the State Assembly, as the government had taken only the consent of the governor before Harish, proceeding with this decision.
I'll have to interject you there, but like you said, since it is also underway in the top court, so we'll keep coming back to you as you keep a close eye on the significant development from the top court. But we'll leave it at that for the moment and shift our focus amid opposition discomfort.